Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Boy, oh boy, what kind of show do I have in store for you all today? New York Marine understanding the weakness of Amber Heard's arguments goes full ham. They take all their weights off and they're just uppercut, finish her in their motion. I mean, it is beautiful. It is gorgeous. It is powerful. It is direct. It is accurate. And most of all, it is supported by the law. So let's get into it, shall we? First and foremost, if you have not been with us, you missed the first two parts that were filed 3 weeks ago and 2 weeks ago. So, real quick recap for those of you who have no idea what's going on and why is this so powerful. Amber, back in December, January, filed a counterclaim after New York Marine sued her saying, "We are not going to pay you. We don't owe you a dime." Why? Intentional conduct. You were found to be in defamation by a jury of 7 in a Virginia state court in a jury trial. Johnny Depp won. And as Andrea Burkhart has recently pointed out, we have documentation to show that the verdict does stand and the money has been paid to Johnny already. So now the question is, the money that has been paid, can she get a recompensation from her insurance company? Okay, that part is done. The trial is done. The appeal is done. It's all over. Money has already been paid to Johnny, and Johnny may or may not have already donated it. I don't know. I don't keep track of every little move that he makes. This is a pretty big move, so I hope somebody is keeping an eye on where that $1 million is going to be donated to, when, and if it hasn't been already. Now, New York Marine and Travelers. Remember, we have two cases. This is the New York Marine versus Amber case. Parallel to this case, we also have Travelers versus New York Marine. Remember that? Travelers is also suing New York Marine saying, look, we paid, you should pay too. Okay? We fucked up by paying. You should screw up yourself too, because we're both on the hook. She paid you for a policy as well. New York Marine is saying, no. We filed this suit in July of 2022, a month after the verdict came down. The jury said, liable, you have defamed Johnny Depp, intentional conduct, intentional tort. And now New York Marine says, whoa, no, we're not paying anything. So they sued Amber, and they're asking the court to basically decide, do we pay or do we not pay? Here are the facts, Judge. She's saying we should pay. We don't want to pay. We believe we shouldn't pay. Fantastic. Now, in December, thereabouts, Amber files a counterclaim, basically suing them back. Oh, you sue me, I sue you. And you get a lawsuit, and you get a lawsuit, and you get a lawsuit. I mean, Amber Heard is practically Oprah with lawsuits, right? So she counterclaims. She says, I don't care that I may or may not have committed this intentional tort. Here's case law, argument, fairly weak counterclaims saying you should pay anyway. And here's why. You had this puffery marketing material on your website. You promised me that you will pay, and now you're backing out on a deal. Honor your contract, New York Marine. New York Marine is saying, whoa. All right, first of all, your counterclaim doesn't even hold water. All right, bitch. That's basically what they're saying. And they took a step further. They filed a motion to dismiss her counterclaim. That's where we are right now. This is the argument that's going to be heard in 4 or 5 days. Okay? In California. The judge is going to decide, does Amber's counterclaim survive the test of a 12b6 motion to dismiss for failure to state a claim upon which relief may be granted? At the top, at the very least, whether or not certain elements of that motion should be dismissed or not. So New York Marine, 3 weeks ago, filed a motion to dismiss Amber's counterclaim that she filed a couple of months prior. Amber, we covered that one. Then Amber replied. That was the last video. It's all in this playlist, by the way, if you haven't checked it out. They're all in chronological order. Okay. Amber responded. We went over that response 2 days ago. And it was replete with just weak arguments and insufficient law. It was just, they had some, some element of cohesence, but cohesiveness, insert your word there. But for the most part, it just, when you have an argument that doesn't hold a lot of water, it will reek. It will have a smell to it, a metaphorical smell. And I'm not trying to be, I know what you're thinking. You're thinking about the grumpy in the bed when I say that. But I'm being dead serious. Like, judges pick up on this stuff. And I know some people on Twitter are calling me out like, oh, I can't wait for the judge to grant like Amber's motion and New York Marine has to pay. And, anything is possible. I'm not discounting that. I'm not saying like she is going to lose 100%. I never said that because that's not what I believe. I believe that Amber has very weak arguments and New York Marine has very strong arguments. That is a fact. And we went over that stuff. So you are welcome to go back in the playlist and see what I'm talking about and form your own opinion. At the end of the day, it's all about how the court is going to rule. And I believe, based on all the facts and evidence so far presented, with the addition of this motion that we're about to go over, that is going to rock your world, I think the judge is going to agree with New York Marine. Maybe they might let the counterclaim slide and keep it in there. But in the end game, because you got to remember, a lawsuit is filled with tiny little battles. We don't always care about the battles. We care about the war. Who is going to win the war? Because you can win 9 out of 10 battles. But if you lose the war, those 9 battles victories don't matter one bit. You see what I mean? So, I saw somebody join on as a member. Oh, yes, there she is. Lily Smith, thank you so much for joining. Don't forget to like this video, comment below, subscribe to the channel, hit that notification bell. Can you tell I'm high energy today? Boy, I feel good. All right, let's roll. This is just so good, you guys. I can't emphasize it enough how beautiful this motion is. It's just mwah, mwah, mwah. It's almost Ben Chu would be like, I curtsy, I bow down to you, sir. This is magic. All right. So McCormick is the law firm, as you all already know. Those of you who have been following this saga, this was filed literally last week. This is a week old. This motion is 1 week old. This is fresh stuff. Fresh stuff. Here it is. The hearing, courtroom 9D, as we all know. New York Marine and General Insurance Companies reply. All right, this is the final motion in this trifecta saga. You have motion, response, reply to the response. That's it. Sometimes you can move for a surreply. There's not even enough time, I don't think, since hearing is literally on Monday and we're already on Wednesday. They can still ask for it, but who knows? Heard was not entitled to independent counsel. Her bad faith claim must be dismissed. Our motion to strike is meritorious. Conclusion. Simple, short, direct. As always, we start with some cases. This is all for judges' reference in case they want to go back and say, oh, yeah, what did that case say about that? Let's begin. Listen to these words. Heard was not entitled to independent counsel from New York Marine. Undisputed in Heard's opposition is that an insurer's offer of a defense under a reservation of rights only permits the insured to decide whether to accept the insurer's terms for providing a defense or instead to assume and control its own defense. This is from Scottsdale. Heard's amended answer and counterclaim alleged that she did not, quote unquote, fully accept the defense proffered by New York Marine because it was impossible to do so. And her opposition confirms that she was not required to accept the defense offered by New York Marine. This is cited directly from Amber's amended answer. Heard's opposition further confirms that her alleged entitlement to recover defense costs consisting of expenses without New York Marine's consent is likewise based on New York Marine's own alleged breach, failure to provide independent counsel. Thus, Heard's entire opposition to New York Marine's motion is predicated, on her erroneous assertion of an entitlement to independent counsel. If you remember 2 days ago on Monday when we covered her response, that is pretty much like 80% of her motion was about, yes, I am entitled to independent counsel, because that's all she's got. And it's a very weak argument, extremely weak, but it's all she's got. And it's supported by like maybe 1 or 2 cases. And on the opposite side, we have New York Marine, who has like, I think 12 or 13 cases that they cited. So right out of the gate, again, when you have a strong argument, you don't have to try. It just rolls off the tongue. When you have a weak argument, you have to play a little gymnastics and be like, hop, like hop, jump, skip, and let me see if I can get her over here. Hop, let's do a little tumble, tumble over there, come back. And now you're just like, okay, I hear your argument. It's cute, creative. I will give you that. Definitely creative. You've done a splendid job of jumping around and trying to prove your point, but I don't feel convinced. Me personally, okay? Like I said, me personally, and I feel the judges may echo the same sentiment. And again, it's very easy for a judge to simply go, you know what? I don't think there's enough here. Let's let the counterclaim go to discovery, see what you find, and come back to me. That's the easiest out for any judge. Always, 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 always. And they will allow the counterclaim to proceed, but then they'll win this tiny little battle, but then they'll lose the war. You see what I mean? Big difference. Big, big, big difference. Hey, what's up, James from court in the house? What's up, baby? Welcome to the party. We are rocking it. Boom, boom, boom. Let's go. All right. Regardless of which state's law applies. Remember, Amber made a huge, huge deal about which state law applies. Is it Virginia law? Is it California law? Here's why it's not Virginia law. Here's why it's California law. Well, New York Marine's like, we don't care. Apply whatever you want. You still are not entitled to independent counsel. Call it a day. Bye. Whether California or Virginia law apply to New York Marine's contractual defense obligations is immaterial. Let me read that again, because here's the thing. If you all remember, Amber Heard spent like 25 pages of her response. They knocked 25 pages out with one sentence. Meh. Mic drop. Mic drop. Just slam dunk. Not even an effort. Not because they have better lawyers. The law is on their side. The factual and legal arguments are supported on New York Marine's side. Okay? Whether California or Virginia law applied to New York Marine contractual defense, immaterial. Moving on to the next point, right? Not literally, but that's basically what they're about to do. Its appointment of Virginia counsel did not create a conflict of interest, since one, regardless of which jurisdiction's law governs its contractual obligations, Virginia Defense Counsel's obligations to both Heard and New York Marine were governed by Virginia laws and ethical rules. And two, under Virginia's laws and ethical rules, Virginia Defense Counsel never operated under a conflict of interest since they only had Amber Heard as a client. See the memo. You don't even need the case law here, because it's all agreed upon. Heard argued that a conflict analysis is required. This is what Amber argued in her motion. and that the government interest test requires application of California law, and that under California law, New York Marine's reservation of rights gave rise to a conflict of interest. Heard's expansive arguments fundamentally misconstrue our position. Where are you, Amber? Are you even listening? They misapply the relevant law and flatly ignore that under California law, a Virginia attorney appointed by an insured to defend an insured in Virginia, even under a reservation of rights, does not have an ethical conflict triggering an insured's rights to independent counsel. Let me read that again because I was a little too hype right there. Just listen to the words. It's like a lawyer's like dream, you guys. This is like what makes lawyers dream hype at night. Heard's, and listen to the adjectives too. The adjectives that they're using, they're not like they're cold, they're not aggressive. They're direct and to the point. Just pay attention. Listen to the words. Heard's expansive arguments, 25 pages worth, I think what you logically call expansive, fundamentally misconstrue New York Marine's position, our position. She's talking about us. They misapply the relevant law and flatly ignore that under California law, a Virginia attorney appointed by an insured to defend an insured in Virginia, even under a reservation of rights, does not have an ethical conflict triggering an insured's right to independent counsel. Now, since I was dinging Amber Heard's brief for typographical errors, I think it's only fair to attack New York Marine as well. That should be an "and," not an "a." Ethical should be an ethical. So minus points there, New York Marine. But the statement is so powerful, I actually missed it on the first read through. I'm not going to lie. This court previously addressed the same issue and argument, albeit raised by travelers in a parallel case. Remember, we have two cases here. This is the first case, or technically second. Travelers versus New York Marine is the first case. This is the second case. Okay. This court previously addressed the same issue and argument raised by travelers and correctly concluded that because Virginia counsel, originally selected by Heard prior to her tender to New York Marine, had only her as a client, no conflict of interest giving rise to a right to independent counsel arose. And they're literally citing an opinion by this court, January 6th of 2022, Travelers versus New York Marine. It's an unpublished opinion. It's a Westlaw site. For those of you who are law and legal aficionados, you will see that 2022 WL site is an unpublished opinion because it's not public yet. It's a brand new case. I know it's a year and 2 months old. Welcome to law, where a year and 2 months ago is brand spanking new in the legal realm. It's just facts. You know, we cite cases from 5 years ago and say it's a new decision. That's facts. With respect to Heard's contention that application of the governmental interest choice of law test altered the analysis under the test, the court is only required to compare the two jurisdictions' competing interests after first determining that there is a true conflict of laws because the substantive law of California leads to a different result. That's Stonewall. But here, there's no true conflict between the laws of California and Virginia with respect to the duties owed to an insured by a defense attorney appointed by an insured's liability insurer in an action filed in Virginia, even if the defense is under a reservation of rights. Both California and Virginia have legal and ethical rules in place to protect insureds from defense counsel being subjected to conflicts of interest. In California, because of the judicial recognition of the existence of the tripartite relationship pursuant to which defense counsel represents both the insurer and the insured, the relationship must give way in the event of an actual conflict of interest, thereby allowing the insured to select independent defense counsel absent an express written waiver as authorized by Civil Code 2860. Now, in contrast, Virginia courts have altogether avoided the entire conflict of interest issue by declining to adopt the tripartite relationship doctrine and instead concluding that even where defense counsel is appointed and paid by the insurer, that defense counsel only has the insured for a client. That's the only difference. As such, since California law only requires giving the insured the option of appointing independent counsel, in situations where the counsel originally appointed by the insurer is subject to a conflict of interest. And no conflict can exist here as a matter of Virginia law even, and ethical rules, because there is no true conflict between the laws of California and Virginia, as the result is the same regardless of which state's law applies. So thank you, Amber, for spending 25 pages doing mental gymnastics, trying to show conflict of laws applies here. California should apply, not Virginia. And then New York Marine, in a page and a half, citing only a couple cases, completely undercuts. Remember, I said pop to the head, pop to the spleen, uppercut, and she's on the ground. Whereas she has been like, whiffing, whiff, 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 for like 25 pages. Very, very, very important. Very important. Nor do the cases cited by Amber Heard support her argument. First, Heard cites to Northern Insurance Company, contending that it holds that when the law of one state would require an insurer to provide independent counsel to fulfill its duty to defend, but the law of another state would not, it raises a conflict of laws issue about the scope of the insurer's duty, and that the ethical duties imposed on defense counsel in the state the defense is provided in do not foreclose the possibility that a conflict actually exists under California law. Heard thus relies on Allied Mutual for its conclusion that applying California law did not harm Washington's interest. Remember that Washington case? And that Washington had no specific interest in having its more lenient standard applied, such that the insurer should have provided the insured with independent counsel in the Washington litigation. Well, as an initial matter, Allied Mutual actually applied the restatement substantial relationship choice of law test and thus did not in any way address California's governmental interest choice of law test as advocated by Heard. There it is. Amber Heard misstating the law. Is anyone surprised? Anyone shocked? Anyone on the floor going, "Be still, my heart"? Shocking. Further, Heard's opposition incorrectly attempts to characterize Allied Mutual as being analogous to the dispute here because she asserts neither Washington nor Virginia recognize the tripartite relationship such that defense counsel represents only the insured, not the insurer, and owes a duty of loyalty to the insured that has no exceptions. What the opposition fails to note, however, and completely ignores, is that although under Washington law, defense counsel may represent only the insured, Washington law also expressly recognizes that the insurer is a quasi-fiduciary upon whom is imposed a heightened duty to the insured, carrying enhanced obligations, the breach of which can subject both the insurer and defense counsel to tort liability. That comes from Tank. The potential conflicts of interest between the insurer and the insured inherent in this type of defense mandate an even higher standard. An insurance company must fulfill an enhanced obligation to its insured as part of its duty of good faith. Failure to satisfy this enhanced obligation may result in liability of the company or retained defense counsel, or even both. Now, in contrast, neither California or Virginia law impose such a heightened duty on an insurer, something that, as you may already see, Amber's team completely ignored, did not inform the court, and failed to mention in its response. An insurer is not a fiduciary under California law and owes no obligation to consider the interests of its insured above its own. And in Virginia, the insurer has the right to protect its own interests along with that of the insured. It is that factor which prevents the development of a fiduciary relationship between insurer and insured. And again, I can't emphasize enough. I know to some of you who do not practice law, this again may seem like gibberish, and I respect that because it's not easy to wrap your head around. For me either. When you practice this stuff long enough, it becomes second nature. But even still, some of these arguments are way above my head. But the point is clear. 25 pages worth of argument are being hydraulically pressed into oblivion within paragraphs. And here's the deadliest part. It's not that the arguments are so powerful. What makes them even more powerful is the simple fact that they're so simple. You don't have the simpler the argument, the more likely it is correct for a judge when they read an opinion. Not always, not always, but in this case, it just seems so obvious. It just seems so clear and simple. You know, if it takes you 10 paragraphs to explain what you're selling as a product, you're probably doing something illegal. You ever heard that phrase? If you need to explain what you're selling as a product or a service in 10 paragraphs, then probably what you're doing is illegal. Whereas if you just have an elevator speech, or even less than that, like a third of an elevator speech in 10 seconds, I practice personal injury and criminal defense, boom, a 1 second elevator speech, then you're probably kosher. Same thing here. Same thing here. We have very clear, succinct counter arguments by New York Marine explaining all of Amber Heard's position that took her so long, with the word vomit that her lawyers just spewed out onto the page, that we were reading, and I was like trying to figure out where they're headed and how they're headed. And look at that, we're barely on page 4, and New York Marine just chopped away about 90% of the main points of Amber Heard's argument in her brief. I mean, that's just powerful, like it or not, no matter what side you're on. That's just powerful stuff. Furthermore, as explained in detail in New York Marine's, excuse me, as explained in detail in New York Marine's motion, and as effectively admitted by Heard, whose opposition does not contend otherwise, so effectively admitted, Virginia simply avoids the conflict of interest issue altogether by declining to adopt the tripartite relationship doctrine and only allowing defense counsel to represent the insured's interests, regardless of the contents, if any, or the insurer's reservation of rights. This undivided loyalty is so complete that insurer-appointed defense counsel can even turn around and represent plaintiffs in actions against other insureds of the same insurer. I mean, that's how deep the rabbit hole goes, y'all. Look at General Security Insurance. Another case. They're calling it Jordan. Since Virginia law, unlike California law, requires the appointment of defense counsel who only has duties of loyalty to the insured, and unlike Washington law, imposes no additional heightened duty on the insurer or counsel, Virginia defense counsel appointed by New York Marine was never subject to a conflict of interest. Nor do the related cases cited by Heard assist her. They go on. For instance, Heard cites Bethlehem as standing in the same conclusion, for the same conclusion as Allied Mutual. Now, unacknowledged by Heard's opposition, again, it's so powerful when you're like, it's one thing to say, look, here's the law, and we believe it supports our position. It's another thing to say, here's the law, here's why it supports our position, but don't look at this stuff over here. Ignore this stuff over here. And then the opposition goes, no, judge, point. That's deadly. That is lethal to any legal argument, any legal position, and any legal advocate. Again, unacknowledged is that Bethlehem addressed underlying litigation which took place in California between parties who had offices in California, were engaged in construction projects in California, out of which the underlying action arose, and which construction projects the insured had expressly informed its insurance broker that the relevant insurance policies were intended to cover. It is thus entirely unremarkable that the Bethlehem court would conclude either that California's interest should prevail over Washington's, or that California law required the appointment of CUMIS counsel. And more to the point, Bethlehem actually contravenes the main thrust of her. Not only that, it actually her own case hurts her position. It contravenes the main thrust of Heard's position here, since its ultimate conclusion that the insured was entitled to independent counsel in the underlying litigation turned on its detailed analysis of whether the claims asserted against Bethlehem in the underlying California litigation gave rise to an actual conflict between Bethlehem, its counsel, and its insurers under California law where the litigation was venued. Is anybody listening? Heard's lawyers, huh? Hello? Knock, knock. Nothing. Absolutely nothing. No response. We reached out, but we received no response. No further comment from Amber Heard's lawyers. Similarly, in Hartford Underwriters, the insured had a principal office in Louisiana. This is another case that Amber Heard's lawyers cited, but was incorporated in Mississippi, operated nursing homes in Mississippi, and was sued in Mississippi on claims relating to the operation of those nursing homes in Mississippi. The Fifth Circuit thus affirmed the trial court's ruling that Mississippi law applied to require the appointment of independent counsel over Louisiana law, which did not. Heard also cites Centex, but Centex does not alter the foregoing conclusion since it applies Texas law based on the conclusion that there was no conflict of laws between California and Texas. Again, cases cited by Heard literally undercutting her own argument. You can't make this stuff up. I am literally dying here. This is amazing work. This is like any of you all play Mortal Kombat. This is flawless victory, in my opinion. Feel free to disagree. Moreover, to the extent that Bethlehem, Foundation, or Centex are germane to the present dispute, they each confirm that the determination here of whether Heard was entitled to independent counsel cannot be made based purely on an oversimplification of California law, and instead establish that the determination must take into consideration the true nature of the parties' respective relations vis-a-vis Virginia counsel under Virginia law. And indeed, this court has been down this road before, correctly concluding that whatever any choice of law analysis might say about whether California or Virginia law applied to the question of whether defendant's obligation to provide to the insured, a Virginia lawyer appointed by an insured to defend an insured has only one client, and that is the insured. As a result, even if this court would agree with plaintiff that California law applied, thereby avoiding the choice of law gymnastics. It's actually funny that we both came to the same conclusion. That is just beautiful. I did not pre-read this, for the record. Thereby avoiding the choice of law gymnastics plaintiff believes defendant attempts. Under California law, it would not have such an obligation because the Virginia lawyer, whose professional conduct is unquestionably governed, measured by Virginia law, has no undivided loyalty. As a result, the court concluded, and this is, by the way, again, citing the Travelers case where New York Marine is involved. Citing it, there's nothing more powerful, by the way, gang, than citing the court's own decision, own opinion in another case that's related to this case in this case. It's basically literally saying, well, you guys who are deciding this said this in this case. So I'm just showing you, if you want to remain consistent and if you're still of the belief of the words that you wrote, 12, 13, 14 months ago, then you must rule in this fashion. Which makes sense, because no judge wants to contradict themselves, especially in a case as popularized as this. As a result, the court concluded that New York Marine could have no cumulus counsel obligation in connection with a Virginia attorney's representation of its insured in a Virginia lawsuit, period, stating that the court had applied California law. Application of Civil Code 1646 does not alter the analysis. This is point number B. Point number 2. Setting aside the general choice of law analysis, the opposition also addresses the application of Civil Code 1646 at length. To this end, the opposition argues that the New York Marine policy does not expressly specify a place of performance. Anytime they say the word opposition, they mean Amber Heard, by the way. And thereafter asserts that Civil Code 1646 compels the conclusion that California is the place of performance for purposes of choice of law analysis. According to Heard's opposition, under Frontier, if the place of performance is not explicitly identified, then it can only be determined based on where the insured entered into the contract. Heard further argues that the place of performance, therefore, must be California because it was not foreseeable that an action would be filed against Ms. Heard in Virginia, and therefore there was no intent that the place of performance would be Virginia. However, the issue of Heard's entitlement, I love that they keep using that word because the whole theme of like Johnny Depp's trial was that she feels entitled. Like I actually noticed the other day, I don't know if I mentioned this, I haven't tweeted about this yet, so this is news to everybody. There was a phrase that Amber used. She said it over and over again. It may have been in the original hit piece, the defamatory hit piece, the now concluded defamatory hit piece in 2018, where she wrote, you know, we live in an era or a place where institutions protect powerful men accused of abuse. Notice the choice of words. She never said institutions are protecting my abuser. You know, if you want to go down the whole Murda using the distancing language, I would never heard. That's what really triggered it. Because this is where people were saying, psychologists have analyzed that Murdaugh was like, I would never hurt Maggie and Paul. He never said I never murdered them or never killed them. I never shot them. He never used those words. He used distancing language, allegedly from his victims is what the argument, how it goes, is I would never hurt Maggie and Paul. I would never hurt Maggie and Paul. It seems like a rehearsed scripted language, you know, and I see where people are coming from. And I agree. There's definitely some truth to that. Same thing with Amber. She never said institutions are protecting my abuser. She only used the words institutions are protecting men accused of abuse. First of all, other than Johnny Depp, there are very few and far in between, number one. And number two, I think there's a few words missing there, which she's really trying to say. Institutions are wrongfully protecting a man I wrongfully accused of abuse. That's the full statement by Amber. But of course, she can't come out and say it because otherwise her whole argument would be undercut and shot to pieces, right? So there you have it. That just struck me the other day because I saw those words again and I was like, wait a minute, isn't that distancing language as well? You be the judge. However, the issue of Heard's entitlement, again, because that's the theme, she's entitled to stuff. They're trying to remind the judges about the Virginia case. They can't talk about it directly, at least not here, but they just want to keep oh, by the way, yeah, the entitled one. Yes. I remember her. It's a play on words and it's a psychological tactic and it's wholly permissible. There's nothing stopping them from using trigger words. That's the word, trigger words. However, the issue of Heard's entitlement to independent counsel is not one of interpretation of a contract, and thus Civil Code 1646 has no application here. Neither Heard's amended counterclaim nor her opposition assert that any particular term and the New York Marines policy should be interpreted differently by virtue of California law. In an unpublished opinion of Farmers, holding that question of which states' respective statutory rules regarding stacking of policy limits controlled was not a question of the interpretation of the insurance policies, but of the statutory law governing the practice of stacking, and consequently holding that Section 1646 does not apply. Furthermore, even assuming the applicability of Civil Code 1646, recent California law holds that the place of performance for purposes of that section need not be expressly specified or stated by the contract, but rather can be gleaned from the nature of the contract and its surrounding circumstances. Thus, in applying that civil code, California courts have long understood where a multiple risk policy insures against risks located in several states, it is likely that the courts will review the transaction as if it involved separate policies, each insuring an individual risk, and apply the law of the state of principal location of the particular risk involved. That comes from Stonewall. Now, Heard attempts to undermine the applicability of this well-established principle based on three cases. The first one, James River. In James River, the court found that where James River was called upon to provide a defense to California venued litigation for its Oregon-based insured under a policy issued to the insured in Oregon, California law applied to govern competing choices of law interests. Admitting the court's conclusion that the parties anticipated a defense in California, notwithstanding that the insured was domiciled in Oregon and the policy was issued there, Heard points to the court's further statement that this conclusion is troubling because if taken to its logical extreme, it indicates that a policy might be interpreted according to different bodies of law, depending on where each defense pursuant to the policy was performed. However, the court in James River failed to consider the holding in Downey Venture that a liability insurance policy issued on a nationwide basis may be construed in accordance with the law of the jurisdiction in which the particular claim arises. Parties to an insurance contract understand this. Moreover, as evidenced by the decisions in Frontier and Downey Venture, as well as numerous decisions following them, the fact remains that the weight of California law holds that under Civil Code 1646, the place of performance includes those locations where the defense obligation may be performed. And fundamentally, regardless of what the James River Court's concerns were, its dicta simply cannot overcome the numerous decisions by California courts expressly concluding that the place of performance of an insurer's defense obligation may be determined by the place where it is called on to provide the agreed upon defense. Heard's opposition's attempt to distinguish the decision in Fireman's Fund likewise failed to withstand this analysis. This is case number 2. In that case, the court concluded that California was the place where the insurer would perform its contractual duty to defend could be inferred, despite the fact that the policy did not specify a place of performance because the additional insured was a restaurant with its headquarters and 200 restaurants located there. In this respect, Fireman's Fund is a clear-cut example of a case where the parties likely had no difficulty inferring at least one likely place for performance of the defense duty, the state where the insured's headquarters and its 200 locations were situated. Clear-cut, right? But nothing in the relevant law or the Fireman's Fund court analysis addresses why the same possibility is not equally inferable in any other location where an insurer's policy might be called upon to provide a defense. Thus, ultimately, Fireman's Fund reflects no more than the application of the same rule applied by California courts and which should be applied here. That the parties understand that a defense will be provided and the contract thus performed in any state and venue where the insured is sued and the defense obligation applies. I mean, that's, again, the simplest answer. The simplest answer is almost always the correct one. Occam's razor. We're literally back into Occam's razor territory. The fact that we're insuring you does not mean that we anticipate that you will remain in California and California forever. You may be sued in Virginia, New York, Texas, Florida, New York, anywhere. I think I said New York twice. Hawaii, Alaska. We don't care where you're going to be sued. There is the presumption that you could be sued anywhere. It's already kind of embedded in the policy. Again, all of this would have been solved if New York Marines policy had a choice of law provision in the contract that Amber Heard signed. I'm still shocked. I'm still shocked that there isn't one. Like, it's so boilerplate. Maybe they were a new insurance company and they didn't know, and they maybe missed it. You know who really needs to be fired? The lawyer who wrote that damn contract. No offense, man or woman, whoever you are. You did this is just sloppy work. Because now look what's happening. Look at the issues that we're running through. All of this could have been avoided if you just written California law applies or Virginia law applies or whatever. Or maybe they left it open on purpose because they didn't want California law to always apply. Because California law, as we have learned, is very strict, right? There's no tripartite relationship. Or excuse me, there is tripartite relationship in California. Some states don't have a tripartite relationship. Having a state with no tripartite relationship is way more beneficial than California law. So you know what? I think I just answered my own question. New York Marine wanted to leave it open. They wanted to litigate choice of law because California law is not necessarily always favorable to their position. So if their insured gets sued somewhere else other than California, where the tripartite relationship is not recognized and conflict of laws becomes a whole lot more cumbersome and easier to deal with, more cumbersome on the litigant, easier for the insurance company. I mean, there's your answer right there. They wanted to leave it open. I take it back. Don't fire the lawyer. That's brilliant lawyer work. It literally just finally hit me. It's a calculated strategic decision in the drafting of the policy itself. Man, that is deep. You're playing 3D chess. I'm playing 2D chess. You're playing 4D chess. Very impressive work. Heard's opposition cites National Union Fire Insurance Company without comment. That case merely superficially concludes that only the law of the state of contracting governs the interpretation of an insurance policy. However, it reaches that conclusion by only applying Minnesota choice of law rules, which mandate that determination, a test and result not consonant with California law or even California choice of law analysis, and thus Donaldson, too, adds nothing to Heard's position. Basically, every case that Amber cited, they're now undercutting. They're saying it's replete with holes. It's got nothing of value. It's not supporting her position. It's worth nothing. I don't know what she's doing. We don't understand why they even cited these cases. They're not helping her position whatsoever. I mean, this is unbelievable stuff. This is absolutely unbelievable stuff. By the way, don't forget to like this video, comment below, subscribe to the channel, join on as a member if you haven't already. All right, back to the show. The opposition also cites West American Insurance Company versus Nativa, which rejects Frontier's conclusion, that the place of performance within the meaning of Civil Code 1646 includes the place where an insurer may be called upon to provide a defense. However, in that case, the issue was whether California law applied to the interpretation of a policy definition of the term occurrence, in contrast to the present case, which does not involve the interpretation of any particular policy term. Again, case doesn't necessarily help. This is number 3. Citing Pitzer College for its holding that a policy's choice of law provisions could not overcome California's fundamental policy establishing the notice prejudice rule, the opposition also appears to contend that the enforcement of Civil Code 2860 is likewise an unwaivable fundamental policy in California. In Pitzer, the court explained that a state rule of law constitutes a fundamental policy only where it is designed to prevent inequitable results and to protect the public interest. Here, there is nothing inequitable about allowing an insured to select defense counsel in Virginia to defend an insured in Virginia, since that counsel has only the insured for a client, and thus no conflict of interest. Moreover, since no conflict of interest exists, there's no public interest to protect. In the absence of a conflict of interest, there can be no equitable shifting of the cost of the harm onto the general public. It is also necessarily the case that, as against California, Virginia has a materially greater interest in the determination of the issue, since the necessary representation was required to be provided by Virginia Defense Counsel, who was and is subject to the Virginia Code of Professional Responsibility. Hurd also asserts that California law provides stronger protections, characterizing Virginia law as a more lenient standard. But again, this misconstrues the nature of the relationship at issue. And the court has previously correctly concluded that Virginia's standard isn't more lenient, but rather is simply a different arrangement with the same goal in mind. Further, even assuming Pitzer's analysis were relevant here, its conclusion that California's notice prejudice rule is a fundamental policy of the state because it is unwaivable weighs directly against Hurd's position. Civil Code 2860 expressly provides that the right to independent counsel can be waived. Since the right to independent counsel can be contractually waived, it is not, by definition, a fundamental policy. Remember, in one of the streams that I did, maybe last stream or the stream before that, somebody even made a very, very funny comment when I said, you can ask your insurer, like, hey, do you mind if I hire my own independent counsel? You don't have to simply do it and then pray for the best. You can ask. And somebody very funny made a comment, said, well, clearly we now know that Amber Heard is incapable of asking for consent. And that just, when I saw that, I saw it after the chat was over, after the live was over, and it just killed me because it's so true. It's so true. All she had to do was ask, like, hey, New York Marine, do you mind if yeah, sure, go ahead. Or no, fuck no, you're not getting it. You're not getting independent counsel. It's kind of, it's cute, but it's funny. Because it's true. All she had to do was ask. She didn't ask. She simply did what she did, and now she's paying the price. As noted above, the New York Marine policy provides nationwide coverage. Therefore, under well-established California law, at the time the parties contracted, they reasonably anticipated that New York Marine might be called upon to provide a defense in a state other than California. They were well aware of that. That's why they established this policy with no choice of law provision. Here, that proved to be the case, with Hurd's conduct giving rise to the underlying action, which, as we all know, is the publication of the alleged defamatory articles, which now are no longer alleged, but I don't know why they wrote allegedly defamatory. This was written a week ago. We already know people like to say she's been convicted. It's not a crime. You don't get convicted of a civil case, or you don't get convicted in a civil case. It's just facts. It's interesting that they're still saying allegedly defamatory. I wonder why. Here, that proved to be the case, with Hurd's conduct giving rise to the underlying action, the publication of the, I think now determined defamatory articles taking place in Virginia, and Hurd being sued in that jurisdiction. Under those circumstances, California law considers that Virginia is the place of performance of the specific obligation undertaken by New York Marine, i.e., the providing of a defense in the underlying action in Virginia. That comes from Downey. Moreover, Hurd's argument that she could not anticipate that she would be sued in Virginia is fundamentally incorrect, as her underlying conduct giving rise to the litigation, authoring an article for publication in a newspaper printed in Virginia, would necessarily require her contemplation of the possibility that she could be sued in that state. So she doesn't even have grounds for that. Fascinating. Kyle Cowden says, I'm so glad to hear a lighter subject than Murda. Hey man, you and me both. Why do you think I've moved on? Thanks for joining. Love your legalese mastery. Thanks, Beautifully Damaged. I don't know how much mastery there is, but there's definitely legalese. 4C Process says, I like how they go through each case to refute them. I mean, that's how legal work is done. Quality legal work. You know what I mean? Quality legal work. Argument number 3. Even applying Civil Code 2860, New York Marine's reservation of rights did not create a conflict giving rise to a right to independent counsel. In addition to her choice of law arguments, Heard's opposition again insists that New York Marine's reservation of rights letter did enumerate a conflict-creating basis for denying coverage, since it implicitly referenced Insurance Code 533. As an initial matter, Heard predicates this argument on a quotation of her own allegation that New York Marine reserved rights to deny coverage on the ground that Ms. Heard behaved intentionally, quoting her amended counterclaim. But New York Marine's reservation simply stated the unremarkable and legally correct proposition that to the extent that California law does not permit an insured to indemnify the insured, no indemnity can be provided. In turn, as California law holds, and as this court previously incorrectly concluded, a reservation of rights letter only creates an actual conflict of interest where it expressly cites a specific provision or exclusion in the policy. Again, that's Travelers versus another, Travelers case that has already been cited, and another case called Celebrity Education Group versus Scottsdale. Accordingly, as New York Marine's motion explained at length, and as this court has also previously concluded, again, notice how they keep going back. Court, you already ruled this way. Why are we coming back to this? New York Marine's reservation is nothing more than a general reservation of rights, since it does not cite any specific, or conduct-based exclusions in the policy. Heard's self-serving recharacterization of what New York Marine's reservation of rights letter actually says does not alter the fact that it did not specifically reserve rights on any particular exclusion, and consequently constitutes only a general reservation of rights, which does not give rise to a conflict of interest requiring the appointment of independent counsel, even under California law, the most lenient of the bunch that she keeps arguing should apply here. So New York Marine is saying, you know what? Basically, you can have it. Even if California law applies, you still lose. That's an extremely powerful statement. Whether true or not, it's powerful. The opposition further attempts to recharacterize the nature of New York Marine's reservation by asserting that New York Marine concedes that it asserted a specific provision, Section 533, and arguing that this claimed distinction renders inopposite the relevant California case cited in the moving papers, as well as this court's prior analysis. But again, this argument fails to focus the analysis on the correct question. As observed by New York Marine's motion, Civil Code 3513 provides that a law established for a public reason cannot be contravened by a private agreement. In turn, the statutory preclusion against the indemnification of willful acts set forth in Insurance Code 533 reflects the public policy of the state of California to discourage willful torts. Consequently, Insurance Code 533 precluding insurers from indemnifying insured for a willful act cannot be waived as a matter of California law, and therefore every general provision of rights letter necessarily impliedly references that provision. The opposition cites two decisions as standing for the proposition that Insurance Code 533 may be waived. However, the first, which is First W. Bank, is an unpublished opinion which under the Ninth Circuit Rule 36.3 may not be cited unless relevant as law of the case, re judicata, or collateral estoppel, none of which apply here. The second, Rusty's Island Ship Company, only superficially addressed the question of whether Insurance Code 533 is an unwaivable fundamental policy before concluding that it could be waived, pointing to a single, then 31-year-old case, Tomrin. However, as more recent decisions accurately observe, Tomerlin's holding was predicated on misrepresentations made by the insured to the insured, resulting in an estoppel. Consequently, the weight of current precedent holds that Insurance Code 533 reflects a fundamental policy of California that may not be waived. See again, Downey, distinguishing Tomerlin and expressly holding that Civil Code 3513 bars waiver of Insurance Code 533. For those of you lost, rightfully so, because this is Insurance Code Fight, number 757,322. But we got to get through it. We got to get through it. They're fighting over which code applies and how, and the court is going to be the ultimate arbiter as to which one is going to come out on top, victorious, etc. holding contrary to Tamerlan that there can be no estoppel where it would defeat operation of a policy protecting the public. For example, in PAC, Southwest Airlines cited above, finding that although insurer failed to properly notify insured as a fundamental public policy, insurer could not be stopped from asserting Insurance Code 533. Accordingly, we're almost up to the next point. Accordingly, and as addressed in New York Marine's motion, a general reservation cannot create a conflict of interest within the meaning of Civil Code 2860. Reservation of rights, which expressly cited Insurance Code 533 and 1668, did not create conflict requiring independent counsel. Boom. Reservation expressly citing Insurance Code 533 did not create conflict requiring independent counsel in another case as well. All right, let's wake you all up. Point number 4. Since New York Marine's appointment of Virginia Defense Counsel did not create a tripartite relationship, sound familiar? She was not entitled to independent counsel. Under California law, where a tripartite relationship is not formed between the insurer, insured, and defense counsel, no right to independent counsel is triggered under Civil Code 2860. In Endurance, which defended the insured under a reservation of rights, expressly asserting intentional act defenses, never appointed counsel to defend its insured, instead permitting the insured to continue using the defense counsel whom they've already retained before its tender. Accordingly, after the insured brought suit against Endurance, it argued that no conflict of interest arose under Section 2860B in the absence of the tripartite relationship, in that the insureds first retained their chosen existing counsel in the Gottschalk's bankruptcy and underlying action, and Endurance never selected different counsel, thus rejecting the insured's claim that Endurance had breached its obligation to them. The court agreed with Endurance's analysis that insureds cannot show that they did not have their own counsel or that they were entitled to independent counsel under 2860. As noted above, under Virginia law, defense counsel only represented Amber Heard. No tripartite relationship ever existed between Heard, retained defense counsel, and New York Marine. Consequently, the content of New York Marine's reservation of rights letter is ultimately irrelevant, since, as California law establishes, in the absence of a tripartite relationship, no conflict of interest giving rise to a right of independent counsel could exist. Therefore, as in Endurance, Heard was not entitled to independent counsel, even if the letter's implied reference to Civil Code 533 would otherwise have created a conflict-triggering right to independent counsel if the litigation had been venued in a state which did not recognize the existence of the tripartite relationship, vis-a-vis Virginia, of course. Also, failing to withstand analysis in Heard's extensive argument that a reservation of rights on the basis of Insurance Code 533, whether express or implied, necessarily triggers a right to independent counsel because the claims against her necessarily raise the question of whether her conduct was intentional or willful, and therefore New York Marine was not entitled to control the defense. Remember, she said, "It is impossible," quote unquote. I had no choice. I had to hire independent counsel because this created a conflict. New York Marine is saying, no. There was no conflict. Therefore, you were not entitled to independent counsel. Make sense? However, under Virginia law, an insured does not have a right to control an insured's defense. A lawyer shall not permit a person who recommends, employs, or pays them to render legal services for another to direct or regulate their professional judgment in rendering such legal services. And a case explained that under Virginia law ethical consideration 5.1, the professional judgment of a lawyer should be exercised within the bounds of the law, solely for the benefit of his client and free of compromising influences and loyalties. Neither his personal interests, the interests of other clients, or the insurer, New York Marine, for example, nor the desires of third persons, such as New York Marine, should be permitted to dilute his loyalty to his client. Because New York Marine had no right to control the defense under Virginia law, and because, as this court has previously concluded under Virginia law and ethical rules, Virginia Defense Counsel represented only Heard, there simply could not be a conflict entitling her to independent counsel. Look at the other case that you court cited, Travelers, because a Virginia lawyer has only the insured as a client. These are literally the court's words. This court that's going to be deciding this case. That's a direct quote from the other case, the Travelers versus New York Marine. Because a Virginia lawyer has only the insured as a client, there is no conflict of interest, regardless of what defendant's reservation of rights letter might say. Wow. And we're not even done yet. This is unbelievable. This is just so good. Point number 5. New York Marine's acts subsequent to Amber Heard's repudiation of its proffered defense do not create an alternative basis for the appointment of independent counsel. Heard's opposition also illogically argues that New York Marine's filing of the present litigation itself gave rise to a conflict of interest requiring the appointment of independent counsel. New York Marine extended a defense in the underlying action to Heard through the Cameron McAvoy firm on October 1st, 2019. Heard admits that she refused to fully accept the defense provided by New York Marine, as she obviously stated many times before. Through the Cameron McAvoy firm, and the Cameron McAvoy firm withdrew from the defense no later than November 20th, 2020. This action was filed July 11th, 2022, 5-6 weeks after the termination of litigation and the verdict in Virginia on June 1st. Nevertheless, Heard's amended answer and counterclaim and her opposition both establish that her true position is that New York Marine breached the terms of the policy from the outset, and that its doing so excused her from fulfilling her obligations under the policy and allowed her to refuse to accept the defense provided by New York Marine. That's literally what she said, that New York Marine's refusal to agree to defend her through independent counsel made it impossible for her to fully accept the defense provided by New York Marine. Case in point. Arguing that because New York Marine, Amber Heard arguing that because New York Marine did not provide independent counsel, Amber was not required to accept the defense provided, and that New York Marine's appointment of counsel did not discharge its duty to defend. However, since Amber Heard was not entitled to independent counsel, she was not entitled to refuse to accept the defense provided by New York Marine, and thus she breached her obligations under the policy by doing so. All you had to do was ask. We keep coming back to the same point. Hey, New York Marine, do you mind if I hire my own lawyers? Yeah, sure, go ahead. No, you may not. Hello? Didn't even try. Didn't even make an attempt. Doesn't that tell you everything you need to know? I mean, we already know everything about her, but doesn't that even tell you further what you need to know, everything you need to know about a person? She didn't even try. She didn't even come up and say, hey, draft an email and be like, hey, you guys, do you mind? Look, this is not working out for me. Cameron McAvoy are just great people, but you know what? They're not for me. Do you mind if I hire my own independent counsel? And wait for the response. Never happened. Never happened. Faring no better is Heard's attempt to manufacture a conflict by asserting that New York Marine's motion's reliance on the no action clause also creates a conflict by evincing its intent to control the defense. Most centrally, her argument ignores that, as noted above, Virginia's law and ethical rules require that defense counsel only have the insured as a client and do not permit others to direct or regulate an attorney's professional judgment, thereby operating to divest an insurer of any otherwise existing right to control the defense. Yeah. Although New York Marine was not entitled to control the defense under both Virginia law and the New York Marine policy, it was still entitled to appoint defense counsel. No conflict where insurer issued reservation of rights and retained counsel to represent insured, as happened in Norman. Heard's refusal to accept that defense breached her obligation under the policy and relieved New York Marine of any further obligation to defend her. The opposition quotes a generalized statement in Safeco, which within the framework of California law explained that the purpose of the no action clause is protecting the insurer's right to control the defense. But that general characterization did not consider the fact that under Virginia law and ethical rules, New York Marine could not control the defense, but still had the right to appoint Virginia defense counsel who would necessarily operate subject to all relevant applicable Virginia legal and ethical rules governing their conduct. Thus, the no action clause would properly operate to protect the interest without also permitting New York Marine to control the defense. Sorry, my nose is itchy. Under Virginia law, someone must be talking about me. Under Virginia law, if you believe in superstitions, I'm not superstitious. I'm just stitious. You ever heard that joke? Yeah. It follows that New York Marine's motions reference to the no action clause does not retroactively create a conflict given Heard the right to independent counsel. However, by Heard having admittedly previously refused to accept the counsel appointed by New York Marine and allegedly incurring other defense costs as a result, it follows that she is in breach of the New York Marine's policy's no action clause. Moreover, the no action clause was never explicitly raised by New York Marine in its reservation of rights letter and has only become relevant upon Heard's own breach of the policy, having predicated both her defense and her amended counterclaim on the proposition that New York Marine was in breach of its obligations from the outset, forcing her to take unilateral action to repudiate its proffer of a defense through the same counsel she originally selected. She cannot now argue that New York Marine's subsequent act of filing the suit, or its reference in its motion to the New York Marine policy's no action clause, retroactively justifies her initial breach. It thus follows that Heard cannot create a conflict of interest based on anything occurring in the present litigation because by the time this action was filed, she was already repudiated. She had already repudiated her obligations under the policy by refusing to accept the defense proffered by New York Marine. Whew, what a mouthful. What a mouthful. One of the most beautiful motions I have seen probably since Ben Chu. And the sad part is there are no words that I can use to describe why this is so beautiful other than in a way that makes sense to a layperson. This motion is making a lawyer weep. And it's just so complicated. The insurance issues, like I said, half of them, even I don't quite materialize because all these insurance sections in California, things I've never dealt with, I will probably never deal with again. But I want you all to feel the fervor, the lightning bolt, the electricity, the fire of these words. It's simply majestic. It's simply majestic. Because this is, again, when the law is on your side, sometimes it doesn't feel like you even have to try. You know what I mean? It simply rolls off the tongue naturally. I thought that's what I said. Did I get it wrong, Olga? I could have sworn that's what I said. I'm not superstitious. I'm just a little stitious. Yeah, I thought that's what I said. But maybe I'm wrong. All right, Let's get back to the beauty. We're almost finished, you guys. We're almost finished. Heard's bad faith claim must be dismissed. It is well established in California that without a breach of the insurance contract, there can be no breach of the implied covenant of good faith and fair dealing. In an attempt to avoid application of the principle here, Heard cites 4 cases which she incorrectly contends support the position that a claim for bad faith may exist in the absence of a claim for breach of contract. However, all of these decisions dealt with claims involving an insurer's failure to investigate or render a coverage determination, allegations not made in Heard's amended counterclaim. Furthermore, Heard's opposition mischaracterizes those cases. I mean, there we go again. Not only did she cite incorrectly 4 cases that support her position, she also mischaracterizes them. Fantastic. Specifically, Heard quotes McMillan that states an insurance company could be liable to its insured for tortious bad faith, despite the fact that the insurance contract did not provide for coverage. However, what McMillan actually says is we also continue to believe that there may be unusual circumstances. Oh, did you forget to mention that, Amber? Oh, my bad. In which an insurance company could be liable to its insured for tortious bad faith, despite the fact that the insurance contract did not provide for coverage. McMillan nevertheless went on to follow the well-established law that the insured's bad faith claim did not survive the absence of a contractual breach by the insurer, citing Love and stating that our conclusion that a bad faith claim cannot be maintained unless policy benefits are due is in accord with the policy in which the duty of good faith is rooted, and holding that because there was no breach of the express provisions of the contract or other interference with the interest the policy was designed to protect, no claim for breach of the covenant arises. Similarly, in Mariscal, simply is not relevant. As the insurer was found liable for breach of the policy, it simply did not challenge the determination that it breached the insurance policy. Argument number 3. New York Marine's motion to strike is meritorious, and Heard's opposition admits facts establishing that it should be granted. Now that's, again, just absolutely beautiful. Absolutely beautiful. No, Darren, Johnny Depp only got $1 million pursuant to the settlement of the appeals. Look it up or ask Chad. Chad will tell you. Chad knows all. Power to the Chad. Heard's opposition to New York Marine's alternative motion to strike again asserts that New York Marine did reserve rights to deny coverage on the ground that Ms. Heard behaved intentionally and concedes that it did. New York Marine made no such concession, and Heard's characterization of the content of New York Marine's reservation of rights letter is, again, a misstatement of what that letter actually says. Equally notable is the opposition's admission. They admitted to this, that the content of paragraphs 7 through 16 of the amended counterclaim, which New York Marine seeks to strike, recite marketing representations made by New York Marine's former parent entities. New York Marine's motion cites well-established California law holding that, number 1, marketing puffery is not generally actionable, and 2, that even when admissible, marketing statements are only relevant to address the party's expectations as to an ambiguous policy provision, not whether or not they're legally actionable. In response, the opposition asserts that New York Marine argues that extrinsic evidence is only relevant where policy language is facially ambiguous. That is not correct. In support, Heard's opposition cites 2 cases, Dorr and Kemp, which she contends support her argument that the alternative motion to strike should be denied. However, New York Marine's argument says nothing about facial ambiguity. Rather, it contends broadly that such materials are admissible only with respect to the interpretation of an ambiguous policy provision. Thus, the cited cases add nothing to the analysis. More fundamentally, however, as observed in New York Marine's motion, and as is undisputed in the opposition, Heard's amended counterclaim does not allege any ambiguity in the policy or CPL endorsement, facial or otherwise, nor does she contend that she relied upon any of those statements in evaluating and obtaining the New York Marine policy, nor do her amended answer or the affirmative defenses therein. Thus, the statements alleged that paragraphs 7 through 16 of the amended counterclaim cannot be material. For the same reason, the opposition citation to Glenfed for the proposition that extrinsic evidence concerning the reasonable expectations of the insured may be admissible at trial does not assist Heard's argument. That case involved a dispute over the discoverability of certain documents purportedly bearing on the breadth of coverage provided to the insured. However, Heard's amended counterclaim does not allege any dispute over the breadth of the coverage provided by the policy. Rather, it disputes whether New York Marine's reservation of rights and its appointment of Virginia Defense Counsel breached its obligation to defend her. As a result, there is no basis to admit extrinsic evidence concerning her expectations as to the coverage provided. Likewise, because, again, as noted and as undisputed by the opposition, at least some of the allegations appear calculated to improperly place the issue of New York Marine's wealth before the jury, her argument that a court may deny a motion to strike without an adequate showing of prejudice also does not suffice to defeat the motion. In conclusion, for the reasons set forth in the moving papers and herein, New York Marine respectfully requests that the court dismiss the amended counterclaim without leave to amend, or in the alternative, grant its motion to strike the allegations paragraphs. Signed, James Wagner, February 27th, 2023, which was last Monday as of the recording of this video. Now, we're not going to go through it, but they did attach an attachment. So we're just going to go through. This is the a document that was attached to this motion. It is actually not a deposition. It's a transcript of a hearing that they held of Travelers versus New York Marine. This is where they're literally throwing Travelers under the bus because Travelers has already conceded and admitted certain things. Feel free to pause it, read it on your own accord. We are not going to be going through it. It's simply a transcript of the court case supporting their position, and it is relevant to New York Marine's case because this is what the court has already decided. You'll see in certain places here where it's actually that same court, because both cases, the New York Marine, you can see right there, the court is making, I don't think that the court actually ruled at this hearing. And this is a hearing between New York Marine and Travelers, because Travelers, if you recall, is also suing New York Marine. They've been suing them since like 2021. But this is a hearing from that case. And it supports New York Marine's position. And you have three speakers. You have Mr. Peterson for Travelers. You have Mr. Wagner for New York Marine. And you have the court, which is the judge. This is the certificate that this was an official transcript with the keywords at the end. Kind of skip through those. Proof of service that it was sent to opposing counsel. That's it. That is it. The TLDR version of this whole thing, if you all are literally just joining us, or if you just skip to the end because you're like, it's a lot of listening, Mr. DUI guy, so I'd rather just you give me the TLDR, the too long didn't read version. I'm more than happy to oblige. Here's the TLDR. In her response, New York Marine is saying Amber has provided arguments that are unsupported by law. She has cited law in her favor that are actually not in her favor, and here's why. They have cited, miscited, misinterpreted, misapplied established law. They have cited cases stating they are in support of their argument when in reality they are not in support of her argument. And therefore, you should rule in our favor. 12b6, motion to dismiss her counterclaim as it has no leg to stand on. That's it. That's pretty much it. Do we need Zinnia break? We need a Zinnia break, don't we? Let's get a Zinnia break going. Let's be very, very quiet. We're looking for kitties. All right, there she is. Sleeping as always. I don't understand how she can sleep with my voice booming over here, but I guess she kind of got used to it. Oh, there she goes. Hi, Zinni. Hi, baby. How are you? She's like, leave me alone. I go back night-night. Hi, Zinni. Hi, baby. Maybe that's what it is. I don't know. Thank you. You see Amber Heard and Travelers both losing, David? It's very possible. It's very possible, especially given the weakness of her position and her arguments and Travelers' arguments, which mirror each other. Yes, Amber Heard finally paid Johnny Depp the $1 million. Andrea Burkhart tweeted about it. And she has provided receipts of the same. She just wants to be left alone. So I'm not going to bug her, you guys. I'm not going to disturb her. I know she wants to sleep. Ooh, that is bright. Let me turn that off. There we go. I don't need any additional lighting because I already got enough light here. Can I? There we go. It's crooked, but who cares? We just need to finish this off. I thought Andrea Burkhart has provided the proof. Did you not see it, Tug Sim? I thought we have the proof in the file. Not literally, but I don't know. Andrea Burkhart came in with the receipts. I kind of tend to trust her. She has come in pretty clutch so far. It may have said unpaid. I can't remember if it said. No, her insurance. Okay. Oh, well. All right. Semantics, Tug Simp. She paid vicariously through her insurance, which is Travelers. Okay. Fair. Okay. Amber Heard paid her debts, but not herself, through her insurance company. which to me means Amber Heard has extinguished her debts through the insurance company. Fair? Is that an accurate statement now? Well, this has been going on, Audra Dick. This has been going on. This has been going on. The case that we just covered has been going on since 2022, July, and Travelers has sued them back in like June 2021. So we all know who's really paying, and that's Elon Musk. Musk is the one who's paying the real bills. It's probably his baby too. There's actually a rumor. When I went to California, there's a lot of chatter about Elon Musk being the baby daddy of Una. Time will tell. Time will tell. So, anyway, thank you all for joining me. Thank you all for providing such entertainment. I hope you all enjoyed this. I mean, this has been absolutely fire, you guys and gals. Amber Heard saga for now is concluded. Actually, you know what? I should check. You know what? I should check Pacer. Give me just a second. I want to see something here before I sign off. This is very, very important. This is very, very important. I want to see if there have been any additional filings on the case, because that will determine whether or not the hearing on Monday is going to have any additional arguments on either side. I mean, if anything, it's a motion for surreply by Amber. There's going to be nothing else. Nope. Last filing is number 44. That's what we just read. So that's it. What's next for the DUI guy? Let's talk about it. So, first and foremost, I want to read your comments. I tweeted this. Earlier today. Here's the list of upcoming trials that we have on the list. We have the Daybell Vallow case in Idaho, where she is accused of killing her two kids, JJ and Tylee. That trial starts next month. Now, speaking of trials, by the way, I was supposed to have a trial today, which obviously didn't go as I'm here. I was supposed to have a trial on the 15th, which I believe is settling as we speak. So that's not going to happen. Then I have a trial on the 21st, which is set to go. It's not a DUI, but it's a highly publicized trial in our own city. I cannot reveal details at this juncture, but you're free to look up the news, our local news, and you will find it maybe. That's on the 21st of March. Then I'm going to the Bahamas. Then I'm coming back on the 28th. Then I'm going to New Orleans for a conference. And my next jury trial after that is April 5th. So I had a couple trials that were moved and a couple of trials that have settled. So again, my last trial was February 10th. I was supposed to have a trial a week, and that hasn't changed practically. It's just they keep getting moved. They're settling. It's the frustrating life of being an attorney. You work around your trials, and then you find out the day of, the day before, a week before, if you're lucky, 2 weeks before, that your trial is not going. So, But we'll see. So the 21st is my next one, and then April 5th, followed by April 11th, April 14th. You know, we're back in the grind. April 21st, April 28th, May 3rd, May 10, May 18, May 25, June 2nd, June 9th. These are all trials. June 14th, June 22nd, June 26th, July 7th, July 11th. It's crazy. I have about 25. August 7th. And I thought I had one in September, but I guess that may not be on the calendar yet. So anyway, those are my trials. Those are my trials here on my home turf. Now, in the country and elsewhere, so we have the Daybell Vallow trial. That is in Idaho, coming up in April. I already asked James from court. James said James is not going to that one because kids are involved. He is not comfortable reporting on the murder of children. And you know what? I don't fucking blame him. It's a tough one. It's an emotionally taxing case, and it's not going to be televised. Thank God. I mean, I am all for televising all cases, but like, I don't know. This one is just so sensitive. Initially, I think the judge said they were going to televise it, and now the judge changed their mind. I may not even cover it, to be completely honest. It's on my list. I'm not saying it's not my list of trials to cover. It's on my list of trials that are coming up. You know what I mean? It's just, I don't know. Even Tug Sim says I agree with James. There will not be any live audio. You have to be in the courtroom. And there is a lawyer. Somebody sent me a link. There's a lawyer that even said you have to like apply for a seat if you want to be inside the courtroom. They're severely limiting media attention on this. Again, I think because kids are involved. I mean, Paul was young, but Paul was over the age of majority. Paul was an adult by American standards. We're talking about missing children under the age of 18, way under the age of 18. So there's going to be it's very sensitive. It's very touching. There's a lot of emotion involved. And so I like the fact that they're not having cameras. You know, as much as like, for example, even juvenile court, they don't do cameras. It's all, well, they do, but they don't allow the public in, and you can't get a recording unless you're a party to the case. And even still, you may have difficulty. You know what I mean? The Idaho 4. So somebody said the preliminary hearing is coming up. It's actually one of the top comments here, Koberger. But that's just the preliminary hearing, and I might be in the UK. I might be in England if I do get to go. So that's okay. So that's first. Daybell Vallow. Then we have Kevin Spacey. So Kevin Spacey, I don't even know what this one is about. Is this his civil case? Is this a criminal case? I'm not going to lie. I am completely in the dark. I know he had a trial in New York. He won, even though everyone still thinks he's guilty. He just beat the rap, as they say. You know what I mean? I don't know. I didn't follow it. It was a very, very old case. And I think people were just over it. They're just like, Kevin, you're a slime bag, but you got off light. You know what I'm saying? It was kind of like one of those trials. I don't really have an opinion because I didn't follow it, and I have no idea what exactly is happening there. So I'm kind of pleading the fifth on that one. But the UK one, crazy TikTok psychic case. I heard about that one. Sarah Boone, is that the one? I think that they may be it. I don't know. It's not on my list. If it's not on my list, I'm catching up. So that's in June. Then we have Petito. So as you can see, pretty much every couple months, we have one in April, we have one in June. Then we're getting a break in May. We're getting a break in July, which is nice. Then you have Petito, which is in Florida on August 14th. Petito versus Landry's. It's not Laundries. I think it's Landry's. Sarah Boone is the suitcase murder. Oh yeah. And what about that one that murdered her black boyfriend, the white cheerleader, the one that beat the shit out of him in the elevator? Wasn't she that trial may be coming up next year too. I don't know if they're going to get around to it this year. Sarah Boone trial is next month. She filmed herself killing her boyfriend by putting him in a suitcase and not letting him out. Jesus Christ. The OnlyFans model, Courtney. Yeah. Sounds like it's going to be a pretty slam dunk. I mean, how do you is she going to argue self-defense? He was going to army kill me. Like what's, I don't know. I'm so out of the loop, but I'm trying to play catch up, as these cases come up. Courtney is in Florida. Yeah, I remember that was a Florida case. So Markle versus Markle, that's going to be a big one. James keeps asking me if I'm going to go to that one. I'm like, dude, we don't even know if it's going to go yet. We don't even know if that's going to go yet. By the way, Bonnie, that is a great defense if you're trying to get a restraining order. Terrible defense if you kill them. Battered wife syndrome is a real deal, but murder, good luck. If you off them, so Markle versus Markle may or may not go in October. Then we have New York. It's literally every 2 months. It's kind of crazy. April, June, August, October, December. Like I didn't make this list up, I just follow the dates. And like I said, it is missing pieces, no question about it. This is just the ones that've been on my radar. Right after the Johnny Depp trial, we started this list. It has been expanded since. These three and Manson were originally on the list. These two have since been added. Markle and Amber Heard, her trial in California. Again, this is skeptical if it's going to go. This is skeptical if it's going to go. This is skeptical. Like these three are very skeptical if they're even going to go. Daybell, Spacey, and Petito, I believe, are all going to go. So Kohberger is the preliminary hearing. What is Texas versus Armstrong? Literally on the same date as the preliminary hearing of Kohberger. What is Texas versus Armstrong, Chad? Does anybody know? Nobody knows. All right, moving on. Sarah. Okay, there we go. Sarah Boone suitcase. Sarah Boone the suitcase. So when is the Sarah Boone trial? Did you say next month? April? Sarah Boone trial. Is it going to be televised? April. All right, so let's quickly add Sarah Boone to the list. Sarah Boone. Where is that case? Florida? It's got to be Florida. It's being televised. All right, so that's going to be a big one. That is going to be a big one. Oh, S. Moore killed a rival and stole her sister's OnlyFans. OnlyFans? Is that a typo? Got to be Florida, right? You trap someone in a suitcase and murder them. The case Jax is reporting on linked to Johnny Depp case in a month. It's going to be huge. Orlando, Florida. All right, let's put it in. Orlando, Florida. And that is in April. Does anybody, since it's coming up so fast, do we have a trial date? Like April what? Sarah Boone trial. There's an article from January 17th. Yeah, it's Orlando. Uh-huh. What about the trial? Her trial, which had been scheduled to begin January 30th, is now set to begin around April 10th. So April 10 question mark 2023. All right, we got that. Let's see. Does Sarah Boone actually have a defense? Hey, they're going to trial, so they're going to come up with something. It's probably going to be somewhere along the lines of, since they weren't married, somebody said in the chat, it'll be battered wife. I said it again because it's so common. Battered woman's syndrome, I imagine. Like he was drunk. When he was drunk, he would beat me. When he was drunk, he would maybe take advantage of me. So I figured the only way to get rid of him is to put him in a suitcase. Otherwise, he was just going to keep doing it. It is a very good defense for like an emergency protective order. It's a very good defense for, you know, why I assaulted him back. It's not a good defense for, and that's why I killed him. It is a defense. It's just not a very good one. It's most definitely going to be postponed. Her lawyer doesn't even have an expert witness yet. Well, look, that's fine. I'm happy to take a break in April because I'm not going to go to the Daybell Vallow trial either. I'm not interested in that case. I will be following it, but I'm not going to be like reporting on it on site. Okay. It's definitely not one to travel to and have a party. It's going to be fucking depressed balls. And that's not what the world wants. The world wants entertainment, and it's really difficult to convert two dead children into entertainment. Feel free to disagree. I doubt any of you will. All right, so Sarah Boone, who's next? Great list. Thanks for the list. I'm struggling to keep up with the dates. Kevin Spacey, when the suitcase, is that November now? So suitcases, status hearing in March. So we're going to have a status hearing on Sarah Boone this month. I thought Spacey trial was done. That was the New York one. Kohberger, Danny Danny Masterson again. Shit. Right. They're retrying it. Wow. But I don't think Danny Masterson is going to be is going to go March 29th. But we'll keep an eye on it. It's also not going to be televised. Since the judge didn't televise it the first time, I highly doubt she's going to televise it now. But I'll put it on my radar because obviously it's a potential. Kohberger, Sarah Boone, Letitia Stouch. Jury selection is supposed to be in 12 days. For some reason, there isn't a lot of people covering it, especially considering when it happened, it was everywhere. Who's Letitia Stouch? Sorry, I'm here. Texas versus Armstrong. It's a murder case. Man's girlfriend allegedly murders his ex-lover. Oh, it's a love triangle. When is the trial for that, Elusive Red? Do you know when the trial date is for that? Did you write mine down, Larry? Hold on. You just wrote, you didn't write a date. You just said next month, JD. June 26th. Oh, yeah, right. Duh. Dumbass. Come on, Larry. You said that on the thing. I'm such a moron. I mean, do I want to add Koberger to the list? It's a preliminary. This is a trial. I'm only adding trials. So Texas versus Armstrong is a trial, right? Texas versus Armstrong. As long as it's a trial, I will at least like have it on my radar. And that is June. No, I'm not adding Koberger. Just drop Koberger. It's a preliminary hearing. It's going to last probably 4 to 6 days, but it'll be televised. We can all watch it. I'm not. I mean, I can. It's a preliminary. It's not a trial. I guess people really, really want me to cover it. You know what? I'm going to do you all a solid, and I'm going to add a non-trial to my trial dates. Koberger, I'm going to write parentheses, not a jury trial, but everybody wants it, so you got to give the people what they want. That one is in Idaho. And that one is also June 26th. It's on the same day as Armstrong starts, which, again, doesn't really matter. All right. What else we got? So Sarah Boone. I think I highlighted where I stopped. There we go. Letitia Stouch. Trial for stepmom to last at least. Trial for stepmom accused of killing Gannon Stouch expected to last weeks. Pled not guilty by reason of insanity. Oh, so this is another Daybell Vallow situation. In January 2020, killed her 11-year-old stepson. Ugh. Again, children are involved. I'm not interested in covering it. Like, I'm with James. That's why I asked him. What about Koberger? I thought Kevin Spacey, Koberger, Landry's, Sarah Boone, Richard Allen, Indiana. Next hearing is June. Richard Allen. They finally found that fucker. I remember that when they finally Kentucky detective investigating possible connection between 2011 double murder and Delphi case. Is that another child murder? I think it is. Man, so many kids. This is so depressing. Why? No, this is an elderly couple. 70 he killed a 74-year-old elderly couple allegedly on May 29th, 2011. So this is like a 12-year-old case come May 29th. It's too much information overload. Courtney Clenny. So Courtney is going to be December 2023, somebody wrote. Oh, it's Steph. Hey, Steph. I don't think you're in the chat right now, but is the trial going to be in December? Courtney Clenny, the OnlyFans model. Let's see. Well, I don't have any confirmation. Oh, hey, Steph. There she is. Scabs Unite. I don't know. It's hard to like keep up with every single one, but I'm doing my best. I'm doing my best. So I'll make this list as comprehensive as I can. And of course, we always have a chance to update it. We always have a chance to update it. You know, it's not like this is the list and thou shalt not pass, you know, add any more cases to it. So the ones that are like later this year, Sarah Boone, OnlyFans chick, Letitia Stouch repeating, Koberger, OnlyFans, Amber, yep, it's covered. Leilani Simon murdered her son again. Not interested. Not sure of the date, but Ohio versus Billy Wagner could be. Maybe something else will happen. Copyright against JD, Sarah Boone. What about the OnlyFans? Markle, and Amber Turd on the list. Daybell Vallow severed. Right. John Corbett. Okay. I mean, that pretty much covers it. When is the... So we don't have the Delphi on here, and we don't have Courtney Clemens. Those will be added in due course. But at least for now, we have more or less comprehensive list of things that are going to be coming out of our judicial system in the coming months. So, well, what's going to be our next video? I wonder. Murdaugh is done. Amber is done. What should we do? Go back to Boozy? Nah. Who fucking cares about Boozy? Someone mentioned Casey White. We'll come back to it. It's fine. We don't have to make a full, complete list right away. Clanny is in December. Yeah, we got plenty of time to add her. That's a full 9.5 months away. We got time. Don't forget to follow me on Locals. Yeah, that's right. Thank you for the reminder. We've got some good, wholesome, non-family entertainment on there. Absolutely not, Poj. That is trash TV. And I don't do trash TV. No, I'm feeling better. I took a break yesterday. I didn't stream. I wanted to do this stream yesterday, but I just, like I wasn't feeling it. I wanted to have that good energy because the motion, I just kind of glanced at it like one top to bottom, and I was like, this is beautiful. I have to have good energy for that. Thank you very much, Freelance. Jazzy's like, always here for Boozy. Boozy bucks! Let's get them boozy bucks, as Nate the lawyer tends to say. Carla's like, Locals is a good time. Highly recommend. Usually I do Locals now on like Sunday nights. It's become a thing now. I don't know how long it's going to be a thing, but I actually ordered one of those like benches that you can put on your tub that I can like set my stuff on. I can put a drink, like tea. I can put some chips. I can put a candle. I can put like my camera on. It's going to be really nice. I am actually about to get a haircut, Tug Sim. People have been asking because I've been gelling my hair. You notice there's a reason I'm wearing a hat right now because my hair appointment is in 3:50 hours. So I'm going to be going to my hairstylist who is going to fix up this mess that I have going on, this Medusa that I have on top of my head right now. So thank you, Alicia. I'm glad you enjoyed it. Hey, KK. Well, the first time I held it, the second time I actually set a tripod. So, all right, you all. I'm going to finish up some work as it's still 4:30 p.m. here on the Eastern Seaboard. I thank you all for joining me. I hope you learned something. I hope you had fun. I hope you come back. And of course, we're going to continue with more DUI guy raw law, unfiltered content. Stay tuned. Don't go away. We'll be back after these messages. Bye, everybody.